USCIS has released a policy memorandum that you need to know about before you submit your application. The agency has released a policy memorandum on February 28th that affects how officers handle cases moving forward. On your screen now is the policy memorandum that USCIS released to its officers, instructing them on how to proceed with cases moving forward. So in the past, if you applied for something with USCIS and your application was denied, the officer had the discretion to either leave your case be or transfer your case to the immigration court so you can start removal proceedings. Now, an NTA is the document that starts that removal proceedings process. It's a notice to appear that tells you where you're supposed to appear in court, when, and the time you're supposed to appear in court. That document gets the entire ball rolling as it relates to immigration court proceedings. The policy memorandum strongly encourages officers to make sure that they issue notice to appear if a person applies for benefits, is denied for that benefits, and has no other status in the United States. So, for example, if you came to the United States on a visitor's visa and you apply for a marriage-based green card and your green card application gets denied and you're no longer in lawful status, the officer is instructed to send your case straight to immigration court so the proceedings can be started against you. So firstly, this is not new. USCIS has always had the discretion to issue notice to appear to people who apply for immigration benefits and get denied. But in the past, they were given more discretion to choose to do nothing or to send the case over to immigration courts. Now, understand that the policy memorandum is requiring officers to transfer the case to immigration courts by issuing a notice to appear if an adverse decision is made, meaning that the person was denied for the immigration benefit that they were seeking. However, the policy memorandum also states that if an individual files for an application and later withdraws that application, if the officer determines that the person is removable under any circumstance, they still can transfer the case to immigration courts. Here's an example. If someone submits an application for naturalization and that person later withdraws the application before USCIS makes a decision, if USCIS determines that that person is inadmissible because there's a criminal charge on their record or the person has engaged in fraud or misrepresentation in their past, USCIS can still transfer the person's case to immigration courts by issuing a notice to appear. So even though the case was not decided because it was withdrawn, the USCIS officer still has the discretion to transfer the case regardless. The important thing to remember is if you're applying for something with USCIS, make sure you're getting the right help and submitting the correct application, and make sure that your case is as strong as possible because, as you can see, you can't afford to get a case denied because if you do have a case denied and you don't have lawful status to fall back on, your case will be transferred to immigration